Hey, Jess. All right, so I can't see the cameras, you guys. They're flipped around the other direction. So I can't read anything that you guys write. We'll have to respond to them at some point in time, later time. But so today I want to talk about, once again, I want to talk about how the indictment by a grand jury, how that relates to the CPS issue and how it relates to a guardianship. All right, so do you want to get in here too at some point? Yeah, you do. You want to get in and talk about? All right, never mind. All right, so again, guys, there's fake accounts that are out there that are pretending to be Jessica and I both. They're not us, right? If you guys have someone contact you asking you for money through the messenger, it's not coming from us. We have never and will never contact any one of you asking you for money by message. Okay? You don't have to pay for us to come to your location because we're not committing to that, right? We're being led every single day to do what's right and what the Spirit's leading us to do. And we're not taking on individual cases. We're taking on the collective, the whole, everybody's issue, because they're all interrelated and they can all be addressed in the same way by the same procedural situation, which is what we're trying to get everybody into. But so if you guys, there's a lot of negativity going around about me, and it has to do with people saying that I'm scamming. Again, that's not me, right? That's coming from someone else. If you guys go and you look at the name of the person who is messaging you, it's not even my name, right? It is Tawanah, and my name is Tanawah. I'm Tanawa, not Tawana. All right, and every single one of these accounts, whether it's Facebook or whether it's TikTok or whatever, it's all Tawanah, not Tanawa. Okay, they've stolen my name, they've stolen my videos, they're pretending to be me, and they're messaging you saying, give us money and we'll, do a Facebook with you or whatever else. Just last week, they stole $2,500 from someone. Again, that's not me. Okay, we don't get money. All right, we've never ever gotten $2,500 ever. And so, day to day, we are operating on maybe $200 to $300 budget tops, at any given time. We don't have a bunch of money, and we're not money because we're not proactively reaching out to you, asking you to give us money. This asshole is. Now, I'm going to tell you that we know that at least one of the people doing it is the Pure Cure guy. All right, and the authorities know that as well. So, he's about to find himself in a whole lot of trouble because he's been stealing from all of you. So, like on the Pure Cure Telegram site, that's him pretending to be me. It's not me. So if anybody comes around saying that we're scamming them, well, I'm sorry, but you got scammed. It's not me scamming, it's you got scammed. And I hate to be, an asshole like that, but what else do you want me to say? I made it abundantly clear that if you want to donate to the tour, we have one Cash App, one Chime, one Venmo, one PayPal. That's it. All right. And they're all exactly the same. This is the We Shall Be Free tour. Therefore, you're donating to We Shall Be Free. Right here. Cash App, Chime, Venmo, PayPal. They are all We Shall Be Free. WESHALLBEFREE. If you donate to any other Cash App, Chime, Venmo, PayPal, or any other source, it is not coming to us. All right? So please don't get scammed. And if you do get scammed, please don't blame me for that, right? I'm out here every single day trying to overcome this and trying to help all of you. And I think that, if I were scamming people, I wouldn't be out going to all these states, doing what I'm doing, trying to help, overcome this, because it doesn't do me any good whatsoever to go to Canton, Ohio and put those people on notice for the crimes that they're committing. It doesn't do me any good. I'm not impacted by the state of Ohio. It doesn't do me any good, but I'm doing these things because we can overcome this by coming together and addressing this in the collective. So again, what I'm trying to put everybody into the same procedural situation. That means that if we can show that the same thing and the same behavior occurred to a large group of people, then we would be able to litigate that large group of people by one single case. That's what a class action is. So, for instance, in the absence of the indictment by a grand jury issue, the reason why we don't have to worry about the bias of the judge or the lies of the prosecutor or the evidence that was not allowed to be admissible, all of those are procedural issues that occur after the arrest. If the arrest is unconstitutional because the arrest derives from a breach of a constitutional obligation, then that's the only thing we got to talk about, right? That's the only thing, nothing more. Because anything after that point would automatically be rendered unconstitutional because it's all tainted by the illegality of the way it was obtained. So again, if the Constitution of the United States of America, if it says in Clause 1 of Amendment 5 that no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, then the question is where is the indictment by a grand jury that was used, right, to hold you over to answer for that infamous crime? If there isn't one, then that means that your arrest derives from a constitutional breach, an unconstitutional act. And if the arrest is unconstitutional, then everything deriving from that arrest must also be unconstitutional because it is all tainted by the illegality of the way in which it was obtained. Right will always produce right, but wrong will always produce wrong. If government is acting unlawfully, then what they produce is an unlawful outcome, right? That's a pretty simple maxim of law. You can never have a lawful outcome that derives from an unlawful act. Now, they're coming up with two different arguments for us, two different arguments, and they're easy to overcome. In fact, Lydia, who's been serving up in North Dakota, thank you, Lydia. Amazing work you're doing up there, helping us serving. She served just the other day in one of her counties in North Dakota, and the county attorney came out and when she was done and said, "Oh no, we're not doing anything wrong. Everything is fine because the Supreme Court of the United States said in the case Hurtado versus California, 1984, that we don't have to do it, right?" And then she also pointed to the North Dakota State Constitution that says that they reserve the right to remove the grand jury should they desire to do so, such as they did. They removed the grand jury. They don't do a grand jury up in North Dakota. So essentially, the two issues are, one, does the Supreme Court of the United States have the constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution? If the Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, does the Supreme Court of the United States have the constituted authority to say, you don't have to do that? You don't have to do that, states. We understand that that's an obligation restricting you, but we're going to say you don't have to do it. The answer there is no, you guys. Absolutely not. Because any amendment to the Constitution of the United States must be consistent with the special amending procedure of Article 5. The Constitution says the way that you would change the Constitution, and it has nothing to do with a judge. It has nothing to do with the Supreme Court. The Supreme Court cannot render the Constitution unconstitutional because the basis of what they would render it unconstitutional by would be the Constitution. So the Supreme Court cannot remove the obligations of government through a judicial ruling, thereby amending the Constitution of the United States in an other than lawful manner, right? If the Supreme Court of the United States believes that it's too burdensome to have a grand jury, or they feel as though that's not necessary, that's fine. Supreme Court of the United States, judiciary, present your case to the people of the United States and get them to amend the Constitution in a lawful manner. And if you don't, then what you've done is unlawful. It's unconstitutional. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution. That must be done by an authentic act of the people in accordance with the special amending procedure of Article 5. In fact, George Washington, in his farewell address, our founding father, even stated that those rights, that they remain until changed by an authentic and explicit act of the people, and that they are sacredly obligatory upon all, both individually and collectively. So they are an obligation to all, individually and collectively, until changed by an authentic and explicit act of the people, in accordance with the special amending procedure of Article 5. Any other amendment or any other change to the Constitution would be unconstitutional. All right? So no, the Supreme Court of the United States has no authority to be able to remove the obligations of the Constitution. But what happened? Well, in 1884, the United States Supreme Court came out in a case called Hurtado versus California. That's Hurtado versus California. And they ended up siding with the state of California's Constitution, not the United States Constitution, but the state of California's Constitution. And they said, well, state of California doesn't do it. That's okay. They don't have to, right? And what they did there was the Supreme Court of the United States, they amended the Constitution through judicial fiat, right? Through a judicial ruling. So the Supreme Court made a ruling that amended the Constitution of the United States, and in doing so, they placed their judge-made ruling at the foundation. No longer the Constitution of the United States. It's no longer the foundation, because the judges, like who we're dealing with today, if we were to go to them and say, oh, you're entitled to a grand jury indictment, and you didn't receive it, they don't go to the Constitution of the United States of America to determine whether or not your rights were violated. Instead, they go to Hurtado versus California, who says you don't have to do it, right? Which means that they are relying upon a judge-made ruling as the foundation and not the Constitution of the United States as the foundation. And that is not consistent with, the American principles. That's not consistent with constitutionalism, or it's consistent with the way in which you would provide such amendment. So when they did do that, what they did was they called that judge-made ruling case law. Case law. Well, unfortunately, here in America, judges don't have the constituted authority to be able to legislate, right? They can't create law, because all legislative power is vested in a Congress of the United States consisting of a Senate and House of Representatives. See, here in America, we did not delegate the authority for the judicial branch to create law or to legislate. We know that. Judges can't legislate from the bench. They can't create law, because they can create rulings and only rulings, but rulings must be consistent with the positive law, because judges are tethered to positive law. So the Supreme Court has no authority to be able to create a ruling, call it legislation, call it law, and then direct all of the states to follow their law, because judges don't get to create law here in America. So that's why in the services that you're seeing, the videos that I'm providing right now, that's why you're seeing Jessica, she's stepping up, and what she's doing is she's laying out the emolument violation, right? You can never pay someone to break the law. Otherwise, you yourself are breaking the law. So that's what an emolument violation is. So she's laying out the fact that the Constitution of the United States of America says you got to do this. The state of whatever isn't doing it, right? And then she's pointing out the fact that, yeah, but now you, legislative body, are paying for those people to break the law or to breach the Constitution, which means that you yourselves are now liable in it as a member of the criminal conspiracy, because you are paying for the crimes to occur. That's what she's doing. And then I'm stepping up, and one of the things I'm saying is that there are three crimes that we're identifying within these affidavits. The first crime is deprivation of rights under color of law. That's Title 18 USC subsection 242, which is any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. Right? The second crime is Title 18 USC subsection 241, which is conspiracy to deprive of rights, which means when two or more persons conspire for the purpose of depriving any person of any right secured by the Constitution, commits that crime. Now, again, these are what's called per se crimes. Per se crimes. They're per se because we don't have to prove that they intended to breach their constitutional obligation. Simply by virtue of the breach, all elements of the crime have been met because their willfulness and their knowledge derives from the promise they make. Government has no right to self-defense for a breach of a constitutional obligation. Never. If you breach your constitutional obligation, willfully or negligently, it doesn't matter. Any breach of the Constitution is automatically a crime because you've implicitly invited punishment should you fail to fulfill your promise. That's the effect of the oath. All right? So there's those two crimes that is being done by the prosecutor or law enforcement and the judge, right? So when the prosecutor decides to rely upon the inferior state statute that permits them to charge by way of information as opposed to indictment in violation of the Constitution of the United States of America, well, if they choose to rely upon that inferior state statute to do so, then they've committed the per se crime of deprivation of rights under color of law. When they bring it to a judge in that state and they say, Judge, I'd like you to hold this person over, all right? And that judge fails to make sure that the proper documentation is in place consistent with what the Constitution so demands, then that judge is also depriving of rights under color of law, but now they've established a conspiracy. Remember, 2 or more persons conspire with the purpose of depriving any person of the rights secured by the Constitution commits that crime. So now you have a conspiracy by and between the prosecutor, law enforcement, and the judge to deprive of rights under color of law, right? Then what happens is that judge then signs this order of arrest, hands it off to the sheriff, and says to the sheriff, please go out and perform this arrest, execute this warrant. That sheriff cannot execute a warrant that derives from a crime, right? Or derives from a deprivation of rights. Otherwise, that sheriff is also depriving rights under color of law, willfully or negligently, it doesn't matter. Even if they don't know that they're doing it, simply not knowing is not justification for having broken the law. Right? Every one of these public officials are involved in this conspiracy and they don't even realize it. They don't even realize it. The sheriff's department are telling their people to go out and execute a warrant that a judge issued because the judge abused his power by relying upon a prosecutor or law enforcement officer who relied upon an inferior state statute to deprive someone of a right that they're guaranteed by the Constitution of the United States of America. That does not negate their criminality. It doesn't, because willfully or negligently, they can be held culpable in that because the breach of constitutional obligation occurred. And anybody involved in that breach or perpetuating that breach is also a member of the criminal conspiracy. No denying any of this. The problem is that the moment that sheriff arrests someone, right, without the lawful authority to arrest them, right, and takes them into custody, right, and puts them into a jail against their will without lawful authority, the crime of kidnapping has in fact occurred, right? Because if you take someone without lawful authority to take them and you deprive them of their liberty, right, you have just kidnapped them, right? They're not being held willfully, they're being held against their will. And then the moment that you bring in ransom, it is always a federal kidnapping offense every single time. And every single one of these people that are put into jail are held for ransom in the form of bail, right? Because they're told, well, we'll let you go if you give us money, right? That's extortion, right? It's ransom. And so the moment that kidnapping occurs, and that's Title 28, subsection 1201, the moment that kidnapping occurs in conjunction with the deprivation of rights under color of law, or the conspiracy to deprive rights, the moment that happens, the punishment as prescribed by law, well, we all know what that is. It is a capital offense as of that moment. Capital offense. These are what the laws permit. These public officials are looking at capital punishments every single time that they do this. Every single time. Every single time. It's not grouped. It's every single time you choose to deprive someone of a right, willfully or negligently, of a right that's guaranteed by the Constitution of the United States, the punishment as prescribed by law is capital. So what we're doing right now is, guys, the legislature has been hands off on this. They don't want to get involved in this because they're looking at it, they're saying, okay, this is a conspiracy between the executive branch, which is law enforcement, and the judicial branch, the judge, but it doesn't include us, right? All these legislators, everyone else, they're standing back saying, oh, this is too big of a deal. We don't want to get involved in this. This isn't our problem. Therefore, we're going to abstain. And they say that it's someone else's problem. Not our problem, someone else's problem. That's not true. That's not the way the system was designed to work here in America. All right. This is why we're bringing in the emolument violation, is because we've got to get the legislators to take action one way or another. We need one of the three branches of government to be man enough, honorable enough, adult enough to actually address the problem that they themselves caused. All right. And we're doing that through the emolument violation. So again, it is a crime to pay someone to commit a crime. And if you are paying someone to deprive someone of a right under color of law, then that means that you yourself are depriving of rights under color of law. That means that you yourself are a part of a conspiracy by and between the law enforcement officer, the judge, the sheriff, in order to proliferate and advance the criminal act, right? That means that every single one of these legislators that we are informing of these crimes, the moment we inform them of a crime, they have to make a decision, right? They have to make a decision. And that decision is either one, am I going to continue to pay people to commit these crimes, in which case I can't claim negligence. I can't say I didn't know, because you've been informed, you've been warned, you've been notified, this has been put on the record, and you made a conscious choice to continue to permit that unconstitutional act to occur, which means that you yourself are part of the criminal conspiracy. Every single one of these public officials that we are informing and notifying, they are all a part of the criminal conspiracy. If you're paying for people to deprive of rights under color of law, you yourself are a part of that conspiracy to deprive rights under color of law, period. Now, the other night, we were in Kentucky. Thursday night, we were in Lexington, Kentucky. And this is the first time that I actually came out and said this, but I pointed out the fact that this is a tough decision, right? I get it. It's a tough decision, what you guys are going to have to make here. And this was, that video's not out. It'll be out here soon. I think Jess is working on it right now. But I said, listen, I know you guys it's a tough decision, because you guys are going to have to choose whether you're going to follow a judge-made ruling or the Constitution of the United States of America. And I get that. That's a tough decision for you guys. But you're going to have to choose, because, and then I pointed out the fact that the United States Circuit Court provides the definition for abuse of discretion. You guys want to know what abuse of discretion is? You would go to the United States Circuit Court handbook. It will tell you discretion. And abuse of discretion has a two-part test to determine if there was abuse of discretion. The second part, right? Don't worry about the first part of the test. The second part says any erroneous view of the law is an automatic abuse of discretion. Any erroneous view of the law is an automatic abuse of discretion. I pointed out to the council members of the city of Lexington that an erroneous view of the law is that in your legal contemplation, that the lowest form of law, a judge-made ruling, is superior to the highest form of law, the Constitution of the United States of America. That would be an obvious erroneous view of the law. Therefore, if you choose to continue to do this, that will be an automatic abuse of discretion, right? And so that's what I added into the service that I provided in Lexington, and I'm going to provide it a lot more as we move forward, because that's something that we certainly need to let them know. Any erroneous view of the law is an automatic abuse of discretion. And if in their legal contemplation that a judge-made ruling is superior to the Constitution of the United States of America, that is an obvious erroneous view of the law, and therefore an automatic abuse of discretion will in fact have occurred according to the United States Circuit Court. Now, anytime that there's an abuse of discretion, there are three crimes that are automatic, per se crimes. Three automatic per se crimes occur. The first is perjury, because you made a promise to do something and you failed to fulfill the promise, right? That's the effect of the oath. So you take an oath and you'll say that you'll do what the Constitution says, and then you fail to do so willfully or negligently, it doesn't matter, right? Then you are already guilty of the crime of perjury, and you've already implicitly invited punishment should you fail to fulfill your promise. That's the first crime, per se, automatic. Now, I want to point out the fact that perjury is a felony, right? Punishable by 5 years imprisonment every time it happens, which means that every single time you deprive of rights under color of law, that is a separate 5 years in prison, right? Every single time. But the second thing is that perjury is a violation of public trust, meaning you can't be trusted by the public. If you commit perjury, you are barred per the Constitution from ever having public office or filling public office ever again, because you're a liar and you can't be trusted by the public. So, this is the effect of the oath that you all took that you're failing to fulfill. That is the first crime that's automatic every time that there's an abuse of discretion. The second crime is extortion, because you are compelling a result through illegal means. Compelling a result through illegal means. So if you're trying to, advance your financial interests, but the way in which you're advancing your financial interests is by breaking the law or breaching the Constitution, then you are compelling a result through illegal means. You are abusing your discretion with which you were invested in law in order to advance your financial interests, which means that you are guilty of the crime of extortion, right? Black's law is very, very clear. Any person who abuses any discretionary authority with which they're invested in law commits the crime of extortion, right? Very clear. Any person who abuses any discretionary authority with which they're invested in law commits the crime of extortion. Third crime is oppression, right? And oppression is typically a tort, but not when it comes to Title 42 and the enforcement statutes, right? Oppression is applying the laws unequally by a person in a position of authority. So if you're abusing your discretion by saying, oh, this person's not going to be protected by the law, but this person is, you are applying the law unequally, which through the 14th Amendment in Article 4 would be oppression, right? You may not apply the law unequally, which is why, when you go into these family court issues and that judge says, well, I'm going to allow this parent to have the right to unalienable access to the children without government interference, but not this one. Judge, you don't have the authority to do that, because that is applying the law unequally amongst like members of society. You don't get to decide who has a right and who does not, because that would be the unequal application of law by a person in position of authority, and you don't have the authority to do that. The law must apply equally to every single person within your purview and jurisdiction. Now, I'm not saying that there's not instances in which we would want to, limit a child's interaction with parents. But what I'm saying is until that's codified in the Constitution of the United States, no judge can apply that law unequally amongst like members of society. That's not a decision that a judge gets to make, ever. All right, so the first issue is, does the Supreme Court of the United States have the constituted authority to be able to amend the Constitution of the United States? No, they don't. All right, no, they don't. Now, the second issue is that was brought up by the county attorney in North Dakota, and that we're seeing across the board that their argument is that the states have written in their constitution that they don't have to do it, such as the state of Washington, where the state of Washington says that no grand jury shall be drawn or summoned in any county. So the second issue is does the state have the right to enact its own alternative legislation and substitute it for the guarantees of the Constitution of the United States of America? The answer is no. Absolutely not. They don't. Because the Constitution provides the overarching requirements that every state must follow. If the states could create their own alternative legislation, substitute that legislation for the guarantees of the Constitution, then what's the purpose of the Constitution, right? I mean, to what reason did we create a Constitution to limit the government if the government that is to be limited and restrained is able to exceed those restraints by their own typical state legislation? No. They do not. And Constitutional Law 171 upholds that. Constitutional Law 171 says that state courts and federal courts are equally obligated to guard and enforce every right secured by and enumerated in the Constitution. So no state can create a law and say, well, we're not going to do what the Constitution tells us we must do, because that would be exceeding the power authority statutorily conferred upon them. Because the Constitution resides outside of the state's limited or statutory governing limits. States do not get to pick and choose which parts of the Constitution they want to follow or not follow. That's not the role that the states get to play within our system of government. They can exceed the limits, right? But they cannot remove the limits, okay? So when the Bill of Rights says that you got to have an indictment by a grand jury before holding someone over for a capital or rampant crime, then any state that says we're not going to have an indictment by a grand jury, or we're going to permit our prosecutors to do something different, right, would be unconstitutional, because that state would be removing a limitation codified and enumerated in the Constitution of the United States. They could say, for instance, that the grand jury must be unanimous, right? Because a grand jury is 16 to 23 people that are impaneled specifically to determine whether or not there's sufficient probable cause to assume the crime has been committed. So the right cannot be removed. No state can say we're not going to do it, right? Or eliminate it, because that would be unconstitutional. But what they could do is they could add to it. For instance, say, well, instead of only 8 people agreeing that enough of probable cause exists, then they could say it must be unanimous. That would be exceeding the grand jury requirement, but they cannot eliminate the requirement. That's the role that states have. Everybody knows that. Anybody with basic, 8th grade civics classes would understand the things I'm saying here. So no state can remove it. They can only add to it. Another example would be like a jury trial. The jury trial is codified in the Fifth Amendment, the Sixth Amendment, Seventh Amendment. The right to a jury trial is certainly enumerated within the Constitution. No state can remove it, because in doing so, what they would be doing is removing that right. But there's a number of states that require unanimous determination from the jury, right? They deliberate and they say, okay, it must be unanimous. And if we don't get unanimous, then it's a hung jury. Then, but there's other states that say, oh yeah, we only need 8 of the 12, for instance, to say that they're guilty, and that's sufficient. That doesn't eliminate the obligation of the jury, but it does go down into a procedural area that I believe that the states would be entitled to be able to make those determinations. They can add to it or provide the specific procedural elements, but they cannot remove the right. All right, so those are the two things that we're facing here. They're both pretty easy to overcome, right? No, the Supreme Court of the United States can't legislate, right? That's codified in Clause 1, Article 1. All legislative powers vested in Congress of the United States. Therefore, if the Supreme Court of the United States decides that they're going to create law, that would be legislated from the bench, and that would be unconstitutional through the separation of powers. The second thing is do they have the right to amend the Constitution of the United States? Absolutely not. Because the Constitution says the way you do it must be done by an authentic act of people in accordance with the special amendment procedure, Article 5. Any other way would be an unconstitutional amendment to the Constitution. So we eliminate the Supreme Court through those two issues. But then it goes down to the states. Do the states have the right to be able to create their own sort of legislation? Absolutely not. Absolutely not. Because the states are bound to adhere to those. Those are the two things that we're looking at. They're easy to overcome. And so when we go to the 14th Amendment, you guys, I'm not going to sit and argue with you guys about the 14th Amendment. If you guys don't like what I'm saying about it, then you're welcome to go and follow someone else, right? But if you come out and you start arguing with me about the 14th Amendment, that's a sure way to get yourself blocked, because I'm not going to sit and argue with you and the intentions of the 14th Amendment. The 14th Amendment was had good intentions. It had good purpose. You need to understand that it wasn't the law that enslaved the people. It was the Supreme Court of the United States in a series of really bad rulings between 1865 and around 1910, proliferated primarily through the Weight Court. The Waite Court is well known for being slave sympathizers. They wanted to advance the slavery institution. Chief Justice Waite made statements to the extent that the 14th Amendment might be on the books forever, but we intend to make it a dead letter, meaning we intend to make it completely inoperable and ineffective, right? He said to make a black man and a white man have to eat together would introduce a whole new kind of slavery, right? These are the things that scumbag said, right, on the record for all to see. Kind of like, Dred Scott versus Sanford and what Taney said about the fact that the blacks are not people, right? I mean, that was what led to the Civil War. So you have to understand, it's not the 14th Amendment that did it. The 14th Amendment had very, very good intentions, all right? The 14th Amendment was designed to address two things, right? And to technically overrule two cases that the Supreme Court of the United States brought in. One was Barron versus Baltimore from 1833, which basically said that the states are not accountable to provide the rights that are enumerated within the Constitution of the United States, that's not a restriction against the state government, it's only a restriction against the federal government. And the other was Dred Scott versus Sanford from 1857 from the Taney Court, where they said that blacks aren't people, right? And the Supreme Court of the United States, in a series of rulings, what they did was they overstepped the intended purpose. They intentionally went around the intended purpose of the 14th Amendment, and they brought back in, through a series of these rulings, these bad rulings in order to proliferate and memorialize the slavery institution. They did it through the Cruikshank case. They did it through the civil rights cases, the slaughterhouse cases, through Plessy versus Ferguson and segregation of the South, through Hurtado versus California, through Hans versus Louisiana. So let me just tell you a couple of cases, what they did. So in the Cruikshank case, for instance, the Supreme Court, so what happened there was that there was a group, so this was after the 15th Amendment. Blacks are able to vote. Yay, we're all able to vote. They're all preserved and protected. But what happened was that a number of the southern states didn't like blacks voting. And so they came out and they were setting up obstacles to prevent them from being able to vote. Like, okay, you got to pay us a certain amount of money, or whatever. You can't be a criminal, and or there's a number of different series of things that they did to try to eliminate the right to vote. So what happened was that a bunch of our brothers, black brothers, they went out and they decided to go to a courthouse and make sure that these people got in to vote. They were going to protect them, right? As they had the constitutional right to vote, they were going to protect them while they came in. Well, a bunch of the white side didn't like that, right? They didn't like it. So they came in, a whole bunch of them came in against not a very large group of black people that were protecting those people coming in to vote, and they killed them, slaughtered them, unalived them. And so then what happened was that the state, I believe it was Alabama, refused to prosecute Cruikshank for murdering these people, right? He refused to prosecute, the state did. So then a federal prosecutor decided to take up the case under the Civil Rights Act, because if you deprive another person of their federal civil rights, then you can be held federally liable for that crime. So what the prosecutor was actually arguing was that these black men, they had the right to live, that Cruikshank clearly violated by unaliving them. Therefore, we're going to bring them into federal court if the states are refusing to prosecute. Well, it ended up going to the United States Supreme Court, right? And the Supreme Court, being slave sympathizers, right, being, what they were, they didn't want to see that case be successful. Yes, Cruikshank absolutely, and his gang absolutely killed these men who had the right to live, but the Supreme Court did not want to rule in the right manner. They didn't want to make the right decision. So what they said was that they said that the federal government, the federal courts, are not in any position to be able to enforce the federal rights of people when states abridge them, right? So in other words, federal government has no power to make a state enforce the rights that are guaranteed by the Constitution of the United States of America. This after the 14th Amendment was enacted, where it says that no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. In 1868, the 14th Amendment said no states can take away, diminish, reduce, or destroy any of the privileges and immunities of United States citizens. The privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights. So no state can create or enforce any law that would take it away. Well, the Supreme Court comes out, in that case, it was early 1880s, I believe it was. So 20 years after the 14th Amendment was enacted, they came out and they said, federal government has no power to enforce the rights of citizens of the United States when states fail to provide them. And it took away all power of the federal government to be able to enforce federal civil rights. That case is still standing Supreme Court precedent today, right? That's one of the reasons why the states or the federal government says, oh, well, we can't get involved. That's a state issue. We have to abstain. We can't get bullshit, right? Bullshit. Because the intended purpose of the 14th Amendment in 1868 was no state shall make or enforce any law which shall abridge the privileges of the United States citizens. So that was one ruling that the Supreme Court made that took away the ability for the federal government to be able to enforce federal civil rights. Another example would be Hurtado versus California, right? Hurtado versus California is the case that we're dealing with. 1884, the Supreme Court of the United States comes out and says, yep, California, you don't do an indictment by a grand jury. You have information included within your constitution. That's okay. You can do information. You don't have to do the indictment, and thus remove the right to an indictment by a grand jury and put into place information and allowed for information to be used as the charging instrument in violation of the Constitution of the United States of America. So again, this goes back to the slavery institution, because if the Wake Court wanted to advance the slavery institution, then what better way to do it than by removing the one thing that exists to protect the innocent from hasty or malicious charges by an overzealous state, right? The one thing that exists in the system to protect the accused is the grand jury. There is nothing else in the system that exists to protect the accused. All right? So when you remove the one thing that exists to protect the accused from the accuser of the state, then don't be surprised if the state will come after you for any arbitrary or capricious allegations that they want to bring. Right? The purpose of the grand jury is to court remove that. They didn't remove it because it was the right decision. They removed it because it fast-tracked their ability to be able to convict lease, right? To be able to go out and arrest some black man for some arbitrary or capricious allegation. Oh, hey, you whistled at this white man's wife. We're going to arrest you now. We're going to bring you into the sham process where we're going to threaten and intimidate you until you finally admit you're guilty, so we can put you on a train bound for the coal mines so we can work you literally to death. Right? That's what happened. That was what was going on between 1880 and 1910, was the ramp up of convict leasing. Right? Convict leasing was green-lighted through Hurtado versus California because now we don't need a neutral, unbiased decision maker to make sure that the state's accusations or the state is not exceeding the power authorities that statutorily conferred upon them, that we will green-light it and allow for the state to be able to bring whatever arbitrary, capricious allegations they want against the accused, and the accused has nothing in place to protect them from those arbitrary, capricious allegations. That was the reason why they did it, was to accelerate incarceration. And remember, the 13th Amendment was a lie, right? It was an absolute lie. It was the amendment that was adopted and ratified by the people in order to abolish slavery after more than 600,000 people lost their lives fighting against what we believe was the slavery institution, right? So we passed the 13th Amendment thinking, oh, slavery doesn't exist here in America anymore. It doesn't exist. But that's not true. What the 13th Amendment says, it doesn't say that you can't have slavery. What it says is neither slavery nor involuntary servitude shall exist except as a punishment for crime. Except as a punishment for crime. So that means that if you say except, it means that you can have slavery, but it must be as a punishment for crime, which means that a criminal, according to the 13th Amendment, is a slave, because you can be enslaved and forced into involuntary servitude if you're a criminal, right? So what happened there with the 13th Amendment was it didn't abolish slavery. It transferred slavery from private ownership into state ownership. The state is now the slave owner, right? Because it's the state that gets to profit off of the involuntary servitude of the slave, the person that they deem a criminal. So today, when we talk about slaves, we're referring to criminals. Those two terms are synonymous with one another. They mean the same thing. And it's been that way all along, because look at the Fugitive Slave Act. A fugitive is a slave, and a slave is a fugitive, right? Remember, in Article 4 of the Constitution, when it talks about a fugitive fleeing from one jurisdiction or one state to another, that state is to return them to the previous state, it wasn't referring to criminals, it was referring to slaves, fugitive slave. So if a slave flees from one state to another state, that state is to return the slave back to the slave owner, the other state. Guys, these terms are synonymous. Slave, fugitive, criminal, all mean the exact same thing, right? A slave is a criminal, and a criminal is a slave. So the 13th Amendment, it did not abolish slavery. So today, what we're faced with is a system where the state decides what is or is not criminal behavior. It's the state that makes that decision, right? Then it's the state that investigates whether or not criminal behavior has been committed. It is the state that accuses you of whether or not you've broken that criminal behavior. It's the state that judges you, right, on whether or not you're guilty of that criminal behavior. And then it's the state that profits off of your involuntary servitude when they take you and put you into a for-profit business for the direct benefit of the state. Where is the neutral, unbiased decision maker in this process? There isn't one, right? That was the role of the jury, grand jury, petit jury. That was the neutral, unbiased arbiter to make sure that the state was not exceeding the power authority statutorily conferred upon them and the limits of power that they have, right, from the Constitution. Guys, again, no man can be judge in his own cause. No man can be judge in his own cause. So when the state, right, when the state is made up of a body of men, and that body of men includes prosecutors, law enforcement, CPS, judges, attorneys, gals, CPS, all of them are part of the body of men that make up the state. That body of men cannot be presumed to be neutral and unbiased when they're bringing the accusation and judging at the same time. Very simple concept. That's why our founders brought into place a neutral, unbiased arbiter, right, to act as a protector from the accused and the malicious prosecution of agents of the state. But today that doesn't exist. It doesn't exist for a number of reasons. One is because the states just outright say we're not going to do it, right? Such as North Dakota, such as Washington, Pennsylvania, Connecticut. You know, these are states that are acting in direct willful defiance, removing the one thing that exists to protect the people from hasty malicious charges by the state, and thus every single thing that the state is doing is in fact unconstitutional because it derives from that unconstitutional act. But then the other states that do it, 99% of the people in those states are not present in that grand jury to confront the hearsay accusation against them. 99% of all grand juries that are conducted do not include the accused. That's an abusive process. That's absolutely a crime. Because the purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. The purpose of the grand jury is to be there to protect the accused. That is a proceeding that is there for the benefit of the accused, not the accuser. That is not there for the accuser's benefit, but the accused benefit. To protect the accused from a prosecutor. And yet 99% of the time, the prosecutor is deciding, we don't want the person to be present so that they can benefit from this proceeding. That is called obstruction of justice, right? Which derives from Title 42, 1981. You see, Title 42, 1981 says all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. All persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. Fifth Amendment is a law of the United States. Therefore, it is absolutely protected by 1981. The grand jury is a proceeding created by the Fifth Amendment, therefore it's also protected by 1981. The prosecutor decides that I'm going to permit my client, the accuser, the right to be able to benefit from the proceeding, but then I'm going to deny the accused, the opposing party, the right to benefit from the proceeding. Well, that's an obvious unequal application of the law by a person in position of authority, violation of the 14th Amendment, Equal Protection Clause, and it's enforceable under obstruction of justice under 42, 1981 and the Title 18 statutes. It is obstruction of justice if you deny or prevent any party in any cause from participating in said cause. That is the crime, obstruction of justice. You cannot prevent any party in any cause from participating in said cause because that is witness tampering, witness intimidation, and you guys go read it. All right? Witness tampering, intimidation is the enforcement statute that prevents them from being able to deny any person any right to benefit from the proceeding that exists for their protection from the person denying you that right to be present. All right, so again, we have a grand jury, and its purpose and its intended purpose was to protect the accused from hasty mischarges by an overzealous prosecutor. So we have a number of states that do not conduct a grand jury at all, which means that today there's more than 700,000 people currently in prison here in America on direct facial constitutional violations because the states did not follow the proper procedures and processes codified in the Constitution of the United States to adjudicate that crime. Which means that the moment that they performed an arrest to hold this person over for an impious or capital crime, that arrest is unconstitutional. Which means that everything coming from that arrest must also be unconstitutional because it's all tainted by the illegality of the way it was obtained. If the arrest is unconstitutional, there cannot be anything constitutional after it. The conviction came months later. The plea bargain came months later, right? If at the beginning the unconstitutional act occurred at the point that you're held to answer for that impious crime, then nothing after it is valid. There's nothing to appeal because appeal would say the judgment is valid, but the judgment can't be valid if the arrest is not valid, right? That's why I'm bringing everybody into the same procedural situation. Instead of going to the end on an appeal, instead of saying, oh, they messed up with the evidence, or the judge was biased, or the law enforcement lied, instead of that, we're just going to go to the very beginning and say, did the state have the authority to perform the arrest? And the answer is no, they didn't. They didn't. In 99% of all cases, they did not have the authority to be able to perform that arrest. And 700,000 of the 99%, 700,000 are direct facial constitutional violations. They didn't even have it. The other ones we're going to have to argue because, yeah, you were denied the right to be present, which is an abuse of discretion, right? Which is the crime of obstruction of justice. Therefore, if the crime was committed in order to obtain an indictment, that's not an indictment. That's an information. Because any crime committed in order to secure the indictment means the indictment doesn't exist. Therefore, those people were all charged by way of information, not by indictment, because the indictment cannot derive from a criminal act, right? Because if there's a crime that's committed in the process of obtaining that indictment's not valid. It's void. Therefore, these people are charged by information, not indictment. All right, so We have, so that's the intent purpose of the grand jury. I'm bringing everybody in the same procedural situation on the indictment side, right? Very simple. If you have been charged with or convicted of a crime, and you were not present in the grand jury, or you didn't receive a grand jury indictment, you can fill out an affidavit, send it to me, and what we're doing is we're grouping all these people together into the same procedural situation, and we're saying their detainment was unconstitutional. They were held to answer for a capital or an infamous crime without an indictment by a grand jury, charged by way of information. That is unconstitutional. The Supreme Court of the United States did not have the authority in 1884 to amend the Constitution in other than lawful manner. The states did not have the authority, the constituted authority, to be able to rely upon a judge-made ruling that was unconstitutional, right, by an overstepping separation of powers, and create their own alternative legislation and substitute it for the guarantees of the Constitution. The Supreme Court of the United States did not have the authority to tell the states you don't have to do an indictment by a grand jury. Therefore, when the states chose to rely upon an unconstitutional judge-made ruling, doesn't matter whether it's from the Supreme Court or not, judge-made ruling, and in their legal contemplation that judge-made ruling is superior to the clear requirements and limitations of the Constitution of the United States, what they created is now unconstitutional, which means that every single contract that they're creating, relying upon that unconstitutional state statute, are all void, without force or effect, as though they didn't even exist. Supreme Court of the United States introduced fraud into the system in 1884, and that fraud then permeated to every single state, and the state said, well, I'm going to follow your fraud, Supreme Court of the United States, in violation of the Constitution of the United States of America, and I'm going to create a law in my inferior state statute that says I don't have to do what the Constitution requires me to do, and then for the next 180 years, we're going to go out and rely upon it to break the Constitution, break the law. Every single one of these people, every one of these convictions are all void. Remember, fraud vitiates any action of the court. Until that fraud is removed, nothing that any court produces can be valid, because the highest court in the land must remove the fraud that they introduced in 1884. And until they do, nothing that any court within the purview of the Supreme Court of the United States is going to be valid. Nothing is valid. Nothing. There's no criminal judgment that can be valid. There's no action of any one of these courts that's valid. So we're bringing everybody in the same procedural situation. Prisoners, right? And like I said this morning, you guys, in my Facebook post, all right, it only takes 3% of the population here in America, you can change anything. Every pundit out there, political pundit out there, will agree with that. If you have 3% of the population here in America, you can change anything. Well, 3% of the population is roughly 9 million people, right? Roughly 9 million. Well, I mean, if we were to go off of just the voting of this last voting cycle for president, there was 100 million. So if we're looking at voting population, 100 million, that's only 3 million people, right? That's much lower. But we have 330 million people. Let's just say that it's off that. We're looking at 9 million. If we had 9 million people, we could change anything here in America. If we had 3 million people voting side, then we could change anything here in America. Every pundit will agree with that statement. We have 2.9 million prisoners right now. 2.9 million prisoners. 3 million prisoners. We have 10 million people pre and post conviction. That means that have already served their time, or waiting sentencing, or sitting in jail waiting for a trial, or the absence thereof. We have 10 million, right? We have 3 million currently sitting in prison. Every single one of them don't want to be there. Every single one of them have been abridged in the same procedural situation that I have been talking about for the last 15 minutes here, right? Every single one of them have been detained and held to answer for that crime without the proper procedures being in place. Which means that I bring with me, right now today, behind me, backing me, is already the 3%, right? we need to come together, because today there's more than 70 million people who have been charged with or convicted of a crime unconstitutionally here in America. 70 million people. Every one of those people could get behind me and what I'm doing, this argument that I have, because they're all part of the same procedural situation. We have another 12 million children that have been unconstitutionally removed from their families through CPS systems in these states that feel as though they know better how to raise the family than the family does themselves. That's unconstitutional. Under the Incorporated Roberts versus United States, JC ruling from 1984, that would be unconstitutional. States cannot interfere with the familial relationship and intimate association between parent and child. So there's 12 million children, right? That's another 12 million that could also get behind this, and I'll explain how and why one moment. Then we have another 18 million mothers and fathers who have had their relationship interfered with, either children removed or, even interfered with by opposing party, by a GAL or, or CPS or whatever it might be. Government cannot interfere with your relationship with your child, nor can your child have their relationship interfered with you. That's what was found to exist and incorporated by the Supreme Court. And I'll tell how that's going to work too. But we have another 18 million mothers and fathers who could certainly get behind this in the same procedural situation. Then we have another 6 million guardianships, elderly guardianships who have had their rights interfered with in the same way, right? The same way they could also get behind this in the same procedural situation. And this is what I want to talk to you guys about, right? Because again, all of these issues are interrelated, okay? Interrelated. They all derive from the same procedural situation. Guys, there's an old saying from St. Augustine of Assisi that says that how incredibly alike are all the tyrants, but how gloriously different are each of the saints. Every tyrant will act the same. Once you determine the procedural situation that they're following, then you could presume that they're all being taught to follow the same procedural situation. So that's what I had to do, was I had to identify the specific procedural situation that they're following, okay? And we did that through the absence of the indictment by a grand jury. So this all boils down to the behavior of the judiciary. You see, the judges are all being taught, whether they're in family court, probate court, criminal court, all the judges are being taught to act the exact same way. We can show their behavior through the criminal court in order to manifest and reflect their behavior within the probate and family court. Because you see, probate and family court are relatively new, right? There's not much empirical data, long-term data on them. There's been criminal court for thousands of years, going back to Magna Carta, right? I mean, and the 1200s. I mean, so Blackstone talks about due process and the breakdown of due process, right? And where it comes from, because of historical data that we can use to show, this is what happens when people act this certain way. That's what Blackstone was doing. That's why we have that data. We don't have the same data for a family court or a probate court that we would have for the criminal court. So let me break it down for you like this, okay? When you have information, when you're charged by information, what is happening is what's called a trial by affidavit. Trial by affidavit. Now, it's well known that with the trial by affidavit, your right to confront your accuser evaporates because you can't put that information on the stand and cross-examine it. So the confrontation clause is eliminated the moment that government brings an affidavit against you and tries you by that affidavit. Information is nothing more than a trial by affidavit. That's all it is. Government received information. They reduced that information into writing in the form of an affidavit and presented it to the state to determine probable cause, and then they go and arrest you based upon that information. It's never been rebutted, right? which is why this sets up what is called an irrebuttable presumption of guilt. Irrebuttable presumption of guilt. Now, we all know that any unrebutted accusation becomes truth at common law. So if you don't have the right or the ability to rebut the affidavit or the information, the hearsay accusations that are against you, right? If you don't have the opportunity to rebut those before you're arrested, then that means that you have an irrebuttable presumption of guilt. It's unrebutted, not gone without rebuttal. And now that information or that accusation or that affidavit is considered truth at common law. They're going to treat it as though it's truth. So the judge, what happens there is that the judge presumes that you're guilty based upon the mere fact of being accused of committing a crime, right? That judge doesn't know. The officer doesn't know. There's no neutral and biased decision maker. They never came and asked you whether or not the allegations are true or get your side of the story. Instead, they presume that you're guilty based upon the mere fact of being accused of having committed a crime. So now you're arrested. You're taken to jail. Your liberty is taken from you, and all these rights that are supposed to be protected by the Constitution are being deprived of you based upon someone, a state agent, accusing you of having committed a crime. That judge is presuming that you're guilty because of the affidavit that was presented as though it's truth. Now, an irrebuttable presumption of guilt, again, is the presumption that you're guilty based upon the mere fact of being accused of a crime. Right? So if you're being charged with a crime and you're presumed that you're guilty based upon a single-sided information that was never verified or validated or rebutted, well, now you're in an irrebuttable presumption of guilt. That's what you're in. Which means that you're not innocent until proven guilty, right? It means that you're guilty until proven innocent. Because with a irrebuttable presumption of guilt, the burden of proof shifts. Normally, the prosecutor and the state must prove that you're guilty beyond a reasonable doubt, right? That's what we all believe, that you're innocent until proven guilty. Prosecutor must prove that you're guilty beyond a reasonable doubt. That's the way it's supposed to work, but not with an irrebuttable presumption of guilt. Anytime, and this is according to Blackstone, you guys want to verify this, verify it to your heart's content. It's all written in Blackstone for all to see. Anytime that there is an irrebuttable presumption of guilt, the burden of proof shifts. And it's no longer the state that has to prove that you're guilty. It's now the accused that has to prove that they are innocent. The accused, the defendant, has to go out and collect evidence in order to prove that they're innocent, which is a shift in the burden of proof. Right? Now, according to Blackstone, this breakdown of due process, this is word for word, you guys, word for word. This breakdown of due process occurs when the system focuses on speed and efficiency as opposed to established procedures and processes.
Officer was flagged down.
Guys, just a second. I forgot. Okay. So guys on TikTok, we'll come back to it. So this is recorded on YouTube, also recorded on Facebook. This wasn't pointed toward me, so I didn't know that it cut off. Sorry. I only have an hour, and then I have to slide across, and it went to inactivity. So just 1 second, TikTok. Whatever you guys missed on TikTok, you guys can pick up from YouTube or Facebook. Sorry about that there. So again, in irrebuttable presumption of guilt, in those particular cases, the burden of proof shifts from the state having to prove that you're guilty to the defendant have to prove that they're innocent, which is not an innocent until proven guilty scenario. It is a guilty until proven innocent scenario. And Blackstone specifically states that this breakdown of due process, it occurs when the system focuses on speed and efficiency as opposed to established processes. Blackstone says it very specifically. This breakdown of due process, it occurs when the system focuses on speed and efficiency as opposed to established procedures and processes. We have an absolute breakdown due process written by Blackstone, talked about an irrebuttable presumption of guilt, right? That we can show through the absence of the indictment by a grand jury issue, by the charging of information. We can show the breakdown of due process according to Blackstone from that issue, right? We can do it. We can win all day long on that one. But that's not my intention. That's not my intention, because yes, we could win on the criminal side. We could beat the criminal judges when they focus on speed and efficiency, right? You have a breakdown of due process because the burden of proof shifts from prosecutor on defendant, and the defendant now has to prove that they're innocent because the state has already presumed that they're guilty based upon the mere fact of being accused of committing crime. So again, that's the behavior of the judiciary in a criminal court. The judge presumes that this defendant is guilty based upon the mere fact of being accused of having committed a crime. That is a breakdown that's the result of a trial by affidavit. How does this apply to CPS? How does this apply to guardianships? Well, in a CPS matter, right, the judge is trained to act the exact same way. They are trained to presume that you are unfit based upon an accusation of being unfit, right? Now your right to have a relationship with your child is being deprived of you, right? And you have to go out and collect evidence in order to prove that you're fit to be a parent, which means that you are guilty until proven innocent. It is the exact same breakdown of due process from the judiciary. That judge cannot presume that you're unfit based upon an accusation or an affidavit from CPS or any other agent of the state saying that you're unfit, because that would be a breakdown of due process when the system focuses on speed and efficiency as opposed to established procedures and processes. It is the exact same behavior of the judiciary, right? But Blackstone doesn't talk about this breakdown due process for the family court because family court's relatively new. We can't rely upon Blackstone's empirical evidence and knowledge dating back all the way to the Magna Carta for this family court issue. But we can for the criminal matter, but then we can show it's the exact same trained behavior of the judiciary. If you have the right to be innocent until proven guilty, right, then that means that you must have the right to be presumed fit until proven unfit. That is the same procedural obligations that the court would have, the judiciary would have, and instead we have them acting in the exact opposite as a result of, the way that they're being trained. They're being trained to presume that you are guilty until proven innocent, or that you're unfit until proven fit. And now they're putting the burden of responsibility onto you to prove that you are not guilty based upon an accusation coming from an agent of the state, CPS, GAL, administrative officer, attorney, whatever that might be, right? You cannot be presumed to be unfit until proven fit, because that would be the same breakdown and shift in the burden of proof from the criminal matter. So we're trying to use the indictment issue, the standard procedural situation, so we can show the same behavior exists with the judiciary, regardless of which type of court it is. How does this apply to guardianships now? I haven't talked much about this yet, guys. I haven't talked much about this yet. But, guys, remember, every single prisoner is in a guardianship. They're in a guardianship. They're in a custodial relationship. The state has taken custody of them because they say, oh, you're not able to be, your own adult. You're not responsible to be able to take care of yourself. Therefore, we're going to take you into custody, which is a custodial relationship. Every prisoner is in a guardianship. Guardianship, which means that the state has guardianship over them and can do whatever they want to them by law, right? Can take all their assets, can sell their property, can steal their property, whatever, because you're in a guardianship. And as long as you're in a guardianship, you are under their control. And they control your Social Security, your SESQV, your vehicles, your house, all of your property, including your children, right? State has control of all that. Remember, CPS is nothing more than a guardianship. It's a child guardianship. The state says, well, you're not able to be a parent, therefore we're going to take guardianship of your child, and now your child is in state custody, right? Which means it's a custodial relationship, right? Now we've got custody of them. We are going to take control of your children, and now the state has custody, guardianship over your children. They're all guardianships. Even elderly instances are guardianships, right? The state believes that they can take custody of this person from you, right? They say, oh, well, you're not taking care of your elderly mother or your elderly father, so we're going to take custody, and now the state is going to have control of that individual. State is going to have custody, not you, right? And once the state takes custody, it's no different than a prisoner. It's no different than CPS. These are all the same thing. We are literally fighting against all guardianships, you guys. That's what we're doing. And so all of these other groups that are, looking at this or looking at that, we got to understand that what we're fighting is literally against all forms of state guardianship. All forms. Prisoners, CPS, elderly, doesn't matter. They're all the same. Now, in elderly guardianships, what is happening there is the same breakdown of due process. It's the same behavior of the judge, because someone comes in, a guardian ad litem comes in and says, yeah, this family's not fit. That person can't take care of themselves. Therefore, we have to take them into custody. And that judge presumes that this person is unfit to take care of themselves based upon an accusation from the state of being unfit. Therefore, the judge presumes that this elderly mother can't take care of themselves because she was accused of, and until she can prove that she can take care of herself, right, she is guilty, right? Thus, guilty until proven innocent. You see, the judiciary is acting the same. The behavior is remaining the same regardless of what type of guardianship it is. It's all the same behavior. And so we can address this behavior, but we will be much more effective, right, when we address it all at once. Probate court is relatively new. We don't have Blackstone with extensive hundreds, 800 years worth of empirical data showing that this is a breakdown due process when you are presumed unfit to take care of yourself based upon an accusation of being unfit. We don't have that 800 years worth of evidence written by Blackstone. In the family court, we don't have 800 years worth of empirical evidence where we can show that you are presumed unfit to be a parent based upon an accusation of being unfit, and that would be a breakdown due process. But we do with the criminal court. We do, right? We do. And not only do we have the empirical evidence to show that this is a breakdown due process, but we also have the specific right enumerated within the Bill of Rights that's clearly being abridged, right? We have it in the Constitution. It's written right there for all to see. So, in order to fight for the unenumerated rights, those rights that are not written in the Constitution, we have to find something that we can attach to in the Constitution, which is why I'm bringing this indictment by grand jury up. Because, yes, we are going to have to fight for the freedom of prisoners, not to be a part of a guardianship. We are going to have to do that. You're all going to have to get behind that if that's something that you want, right? But we have to do that in order to fight for other forms of guardianships because Thomas Jefferson said, we gain civil rights as a result of choosing to protect and defend the rights of others. If you want to claim that you have the right to not be a part of a guardianship, then you're going to have to fight for all forms or fight against all forms of guardianship. All forms. Because we can't pick and choose who gets a right and who does not, who's protected by the Constitution and who is not. We don't get to do that. Now, I'm going to say that I'm not saying that we need to let dangerous people out. Don't get me wrong, you guys. That's not what I'm saying. I've never said that. Never once have I ever said that. Right? But what I'm saying is that if the Constitution protects us from state guardianships, then we have to observe that and honor that. We have to. Right? And we have to for all persons. So instead of taking our people and locking them up into a for-profit business that is for the direct benefit of the state, that the judges and prosecutors and attorneys and law enforcement and everyone else profits off of, instead of doing that, well, let's put them into a civil incapacitation, right? Let's put them into a hospital and let's get them the treatment that they need. Let's allow the medical profession to decide when these people are not a danger to society anymore. We have plenty of nations that have gone this direction that we can look to, a restorative-based justice system that we can see it is effective and it works, right? It works. Sweden today is shutting down their last prison. They don't have a prison anymore because they chose a restorative-based, health-based system as opposed to a punitive-based justice system like we have today. The issue of morality is not a matter of punishment. It is a matter of public health. And the moment that we swing and understand that is the moment that we will overcome the injustice of this system, right? The matter of moral issues here in America is not an issue of punishment. You don't take hurting people and put them into a more hurtful situation and expect them to suddenly be healed. That's not how it works. The issue of morality is a matter of public health, and we've got to treat it as such. So we have to fight for all forms of guardianship. I know that it's a tough thing for you guys to do, to say, okay, we're gonna rally behind prisoners, but the prison issue is specifically written in the Constitution. There's no denying it. It is a facial constitutional violation. It is written for all to see. I can easily overcome it, and I will. I will for the prisoners. But I don't want to just do it for the prisoners. I've never just wanted to do it for the prisoners. This was never about just prisoners. This was about all forms of guardianship. This was about all people of the United States being free from state guardianships. Doesn't matter whether you're an elderly person or a child, no person should be owned and governed by a corporation. The state does not know better how to raise the family than the family does themselves, you guys. So I'm going to fight this for the prisoners, and I'm going to win for the prisoners. But I keep asking you guys to please let me win for you too. Because you can't fight an unenumerated constitutional right the same way that you can an enumerated one. I can show the behavior of the judiciary and the breakdown of due process that exists for the absence of the indictment by grand jury, charged by way of information. I can show that all day long for the criminal court, right? I can do it. But I can also show the same breakdown due process that exists in family court and in guardianship and probate court. I can show that the judge's behavior is exactly the same. And if it is a breakdown due process in a criminal court, then it must also be a breakdown due process in probate court and family court. Right? But nowhere in the Constitution does it say that you have the right to a relationship with your child. Nowhere in the Constitution does it say that you have the right to be free from guardianship of a state. But it does say that you have the right to a fair and neutral proceeding, right, in front of a fair and neutral decision maker before you can be placed into a guardianship for a criminal matter. It does say that. The Constitution says that. So if I can win that argument, I could win these other arguments. Good. But you can't point to the family matter, right, and say, oh, it's protected by the Constitution. It doesn't say that. Nowhere in the Constitution does it say anything about your family. It doesn't. Because our founders and forefathers, they unfortunately didn't care about the family because they thought the Constitution was more importantly to protect their property. And thus they put into place a number of provisions that preserve their property without realizing that the most important property that we have is our family. And I've been very, very clear that the first act of our government should have been the preservation of the family, not the last act where we're at today. We're going to get the family protected through an amendment to the Constitution of the United States, but it must get amended. It must be written within the Constitution, right? You're not going to be able to fight it the same way. And not only that, but you don't have the historical data that we do with the criminal court. So everything I'm doing is against the judiciary and the criminal acts that the judiciary has been teaching their followers for 243 years, right? That when the Supreme Court of the United States, the first 28 Supreme Court justices that served on that court, 22 of them owned their own slaves, who put into place a bunch of rulings whose rulings were intended to preserve and protect their property, thus proliferate their institution, and then we wonder why we're fighting against slavery here today. Because judges back then thought that their rulings were the law. We create the law. What we say is the law. States, you got to follow what we say. And we're saying today, everything that you put into place, slave traders and slave buyers, is completely void because it's not consistent with the Constitution. Judges don't get to create the law. So everything that they created, their rulings that they erroneously called law, is not law. It's unconstitutional because it's from a branch of government that doesn't have the authority to create law. It's from a branch of government that doesn't have the authority to amend the Constitution of the United States. All right, so that's kind of where we're at, guys. This last week, we had a good week. All right, we had a good week. We served city of Pittsburgh on Tuesday. So we've had quite a few in Ohio now. I think 4 or 5 cities served. We did, gosh, I want to say 6 or 7 within Ohio this last week. Thursday we went into Kentucky, into Lexington, Kentucky, and we got that state served. We wanted to get into Louisville, but Louisville only allows for virtual meetings, right? According to city clerk, they only do virtual meetings in Louisville, Kentucky, and they're not set up to allow for private or for public comments in their virtual meetings. In other words, there's no way for the people to speak directly in a public forum to their elected representatives in the city of Louisville. That's the only city that we found so far that claims that, but you cannot provide a public comment to the city of Louisville, so we did not get in there. But we did do Lexington, and that was a fairly large city. And like I said, I did change a little bit of the things that I say because I wanted to point out the fact that I know it's a tough decision, but you guys are going to have to decide, am I going to follow a judge-made ruling or the Constitution of the United States of America? Am I going to fulfill that which my fidelity is bound to, or am I going to follow something that is not even law and completely erroneous? So I wanted to lay that out to them, and that's going to be part of my narrative, I think, going forward, because again, an abuse of discretion is any erroneous view of the law is an automatic abuse of discretion. So if those public officials, those council members, if they choose to continue to pay public officials, despite being made aware, Constitution says this, but judge-made ruling says this, they're going to have to decide, who am I going to follow? Am I going to follow a judge-made ruling, right? Or am I going to follow the Constitution? That's the decision that they're going to have to make. That's the decision that all of these people have to make, actually. What are you going to follow? Are you going to follow the flawed decision of the Supreme Court of the United States, hoping and praying that I'm wrong, right? Or are you going to obey the object of which your fidelity is bound? Right? That's a tough decision. I get that. That's a difficult decision that these public officials, every single one of them, is going to have to make. Are they going to follow case law or the Constitution of the United States of America? Right? That's why I want to, moving forward, I'm going to lay this out for them. That an abuse of discretion, according to the United States Circuit Court Handbook, is any erroneous view of the law is an automatic abuse of discretion. And an erroneous view of the law is that in these public officials' legal contemplation, that the lowest form of law, a judge-made ruling, is superior to the Constitution of the United States of America. That would be an obvious erroneous view of the law, because the Constitution of the United States of America is the foundation. That is the supreme law. So if you rely upon any inferior law to that, or any inferior ruling, or doesn't matter, if you rely upon something other than the Constitution to not follow the Constitution, that would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion has occurred. And again, according to Blackstone, 3 crimes occur: crime of perjury, crime of extortion, and the crime of oppression. Obstruction of justice. So if you compel a result through illegal means, if you abuse the discretionary authority with which you're invested in law in order to abridge your obligations codified in law, Constitution in particular, that is extortion. And Blackstone is very clear that every public official who abuses any discretionary authority with which they're invested in law commits the crime of extortion. Simple as that, right? So again, we had another great week. We had a bunch of services in Ohio. We were in Kentucky. We're going into a long weekend here. I want to say thank you so much, Angela, or Andrea, for giving us this amazing Airbnb to be able to set up for the weekend. It's a huge blessing, you guys, to be able to have a place to stay. This is amazing. I woke up to this morning and was like, all right, this is awesome. We got in really late last night after a 14-hour drive, but we'll be back on it on Tuesday morning. I want to say, guys, that you guys have been coming through like you wouldn't believe. It's been amazing. We didn't get an RV like I had asked the last time I was alive, but we did get a trailer. We've had to donate a trailer that can be pulled behind our van, one of those little teardrop, 2,500 pound trailers that's been donated for our use, which is amazing. Thank you, Dave. Thank you so much, brother. And so that's going to be huge for us, huge, because honestly, that's going to be able to keep us on the road. As long as we got gas, we won't have to worry about anything else other than driving. But we do have some things that we're going to have to get. Again, you guys, if you've been scammed, it didn't come from me. The only time I ask for anything is right here. You guys are welcome to donate. We don't make money. Anybody that knows us knows that we are struggling from day to day to be able to do it. But we do have a couple things we need, guys. We have someone that is offered to install the brakes, and we need new shocks. We have to get new shocks because the shocks in the rear end of the van cannot hold the weight of the trailer. So we got to get new shocks, and we have to get a hitch, right? So we do have some absolute needs, but we do have Jesse James, brother, who has offered to install in his shop, which is incredible. We will be able to get that done, but we do need the money to be able to pay for the parts so that he doesn't have to bore any of the cost. So if you guys want to donate, you guys want to keep us moving, you guys want to see us continue to provide these services, everything is coming together. You guys can. The only way you can donate is Cash App, Chime, Venmo, and PayPal. It's the only way. We can't accept any other way, right? And it is only We Shall Be Free. If you donate to anything other than We Shall Be Free, it is not coming to us, right? This is the We Shall Be Free tour. Therefore, We Shall Be Free is the only one we provide. If anybody contacts you and asks you to give them money, it's not coming from us. I have never, and we will never message you asking you for money. We will never offer our services through a message to you. Anybody that knows us also know that. So if anybody contacts you, right, and you get scammed, please don't be mad at us. Don't be mad at me. And if you come out, and say negative or derogatory things about me as if I'm scamming you, then you're going to be blocked. I will block you immediately because I'm not going to put up with that, right? I'm not out here scamming anybody. I'm not making a bunch of money. There is someone that is. And again, I'm going to say that person is the Pure Cure guy, Purecure, Pure Cure. He is the one that, or one of the people that's stealing from you. He's also the one that's pretending to be Jessica under Justice Without Lim, L-I-M, not limits, but L-I-M. That is Pure Cure. And he is stealing from all of you. He's doing it through Telegram as well. The authorities are aware of it, and he will soon be held accountable for the thousands of dollars that he's stolen, pretending to be me, that all of you are believing that I'm scamming you on, but I'm not, because the money isn't coming to us, it's going to him. All right. If you want to donate to us, it's we shall be free. That's it. We shall be free. And we do have some actual tangible expenses that we're going to need. So I would welcome whatever blessings you guys can give to us. But it's amazing. We now have a trailer that we can pull behind the van that will be able to keep us at least set up so that we can have a place to be in and sleep in and so on. So that's a huge blessing for all of us. And we might even have room here soon for an extra person to be able to travel. But and we're still praying for the RV. The RV will come, but God has blessed us with this one right now, which is amazing. So thank you guys so much for everything you guys have done. I think that's about it, guys. I can't read anything here, so I'll have to come back and go through all of the comments that you guys have, and I'll do what I can. So we're back at it on Tuesday in a different state. We're 14 hours away from Kentucky, wherever that might be. We are planning another trip back west right now, but to get the RV, we got to actually go back east first. And so next week is going to be dedicated to that. We're gonna have to do that. But then that would put us into the following week, heading back west. Guys, we're going to continue to do this until the court agrees to hear the case, right? And so if you guys want to get out there and you want to help us, you want to serve your local city council, your local county commissioner, you guys can download the script to read and the notice to provide from justicewithoutlimits.org. It's justicewithoutlimits.org. So you can go out, you can download the paperwork from justicewithoutlimits.org, and we would welcome whatever support we can get. There's only so much that Jessica and I can do. We're out here leading because I believe that the best leader is one that actually leads by example. Because if I don't believe in something enough to actually be out doing it, then maybe I need to work on my faith a little bit. I know this is going to work. I know we're right, and I know that it's going to work. And so I have no problem doing this. And I would ask that you guys help us out however you can, getting out, serving your local legislatures as well, because that will be a big help. The more noise we make in the short amount of time, the better, right? The court will have to hear this eventually, but what's going to get them to hear it is going to be the point in which, the states or the court is no longer able to ignore it, right? And that comes from noise. That's why we're out here having public hearings, right? So the public can hear this, so we can spread this information and get into that court to be heard. We will win. There's no doubt about the win. It's just a matter of about winning, but the matter is when that is going to happen. When the court can no longer ignore this and will have to address it. That's the real question. So we need to make as much noise as possible, and that's why I wanted to make sure that even if you're in family court, right? If you want to help, we have to go after the indictment issue, because that's what's enumerated. That's what the Constitution says. If you want to help and you're dealing with probate court, your family, your mother, your father, you know, how you help is reading the script that we have. And that script is going to be focused on the guardianship of prisoners, right? And it has to be that way, okay? But in order to abolish all forms of guardianships, we've got to attack the guardianship that we have the empirical data on, right? The guardianship of criminals and the abridgment of the fundamental enumerated constitutional right. Now, I'm just as scared as some people about what could happen, but I've never said and will never say we're going to let dangerous people out on the streets. But I'm also going to say that God has made very, very clear that we're to set the prisoners free. We're set the slaves free. No denying that. And I want to reiterate the fact that every single prisoner is someone's child, right? They're someone's child. And I don't care if that child is 50 years old or that child is 2 years old. That child deserves to be healed from the trauma that was inflicted upon them by an institution and a system that decided to advance their own selfish financial interests, right? No person should have to be sitting in a guardianship under state so that the state can profit financially off of that guardianship. It doesn't matter whether it's a child in guardianship, an adult in guardianship, or elderly in guardianship. There should not be any guardianships. No state, no corporation should ever be able to have control over a human being. That which is created cannot be above the creator. And so if we want to abolish guardianships in all forms, then we must fight against guardianships in all forms. So if you guys want to help, please get behind this and please go out to your local city council, your local county commissioners, and read the script that you can download from justicewithoutlimits.org. And guys, this is working. This is working. Because just last week, we got a response back from the North Dakota Attorney General, who is going to provide an official response to the services that Lydia has been providing up there in North Dakota. It's not going to go the way that we want, but that's fine. At least they're coming out to debate us, and that's 99% of the battle right there, right? I would welcome any debate, because there's not going to be any debate that they present that will be constitutionally valid. They cannot rely upon the Supreme Court amending the Constitution, and they cannot rely upon the state having the authority to go against the Constitution. And those are the only two arguments that they've ever presented. All right. Constitution stands in its entirety until there's an explicit and authentic act of the people in accordance with the special amendment procedure of Article 5. Those obligations are sacredly obligatory upon all, both individually and collectively. All right. Through the fraud introduced by the Supreme Court of the United States in 1884, we can vitiate every single criminal guardianship that the states have put into place. Vitiated, meaning that they're fully void without force or effect. They don't even exist because they all derive from an unconstitutional arrest, because the Supreme Court of the United States introduced intrinsic fraud the moment that they said we're going to amend the Constitution in other than lawful manner. And through that, we can show the exact same behavior of the judiciary against the CPS issue, as well as also the elderly guardianship issue, the probate court issue. We can vitiate all of them, right? So that's why we're asking for help. Only need 3%. 3% of the population, and you can change anything here in America. Every pundit would agree with that. 3% of the population. So 2.9 million prisoners. Every single one of them in a guardianship that they don't want to be in. That's what I'm bringing to the table. That's what's behind me. Every single one of them will act in solidarity, completely behind and backing what I'm doing. That's what I bring to the table on the indictment issue. If we can get the family court and the probate court to come together with their resources as well and say, you know what, we're going to back this. We're going to get that 3% and then some. We're going to exceed whatever we need, and we will be able to change anything here in America, right? The judiciary must comply with the limitations of power codified in the Constitution of the United States of America, because that's the only reason why any judge exists here in America. There's nothing else gives a judge any power but for the Constitution. So if they exceed the power of the Constitution in any way, they have acted unconstitutionally. All right. So this battle is not against the local judges. This battle is not against the local prosecutors. Hell, this isn't even against the state attorney generals. This battle is against the Supreme Court of the United States because of the fraudulent ruling that they put into place when they chose to overstep the separation of powers, legislate from the bench, and put into place a ruling that amended the Constitution of the United States in an other than lawful manner and directed all the states to follow their ruling in violation of the Constitution. That's the battle. And if we can beat the Supreme Court of the United States, then we will see the relief throughout all the states. All the states, their laws will be rendered void, which means that all the contracts that were created relying upon those void laws will also be void. But in order to get to the Supreme Court, you have to make a lot of noise. We have to make a lot of people aware of an issue. And until we're able to do that, we will not be heard by the Supreme Court of the United States. So I want you guys to know, I have no control over the timing here. I can tell you that the argument we're going to win, right? I can tell you that lawfully we can't lose. But what I can't tell you is when the case will be heard, because I don't control that, you guys. That's out of my hands, right? That's going to require the court to step up and do what they have to do. And in order to do that, I need a lot of people to know about one major issue. A lot of people know about it, which means I need a lot of people helping me spread that information. Because Jessica and I are only two people. We can only go so many places so often. We can only do this. We only get so many people viewing these videos, right? I need your help, right? I need your help. So if you want to see this be successful, I need you guys to get behind it, support it, and spread this information, because I will advocate on your behalf. I can do that, right? And I'm prepared to do that. You guys have heard me talk about this so many times. You guys know that I understand these issues and I can overcome it. So let me advocate on your behalf. Let me fight for your family. Let me fight for your children. Let me fight for your own freedom. Let me do that, right? But you guys are gonna have to get behind it, and you guys are gonna have to, help share this information. So if you believe in the things I'm saying, if you believe that in what I'm trying to accomplish, if you believe in it, then I would ask you to please get behind it. Get out there and serve your local city council, your local county commissioner. Put them on notice, and together we will be free. All right, so I don't control timing. Wish I could, but I don't. The only thing I have control over is getting out here and doing what I'm doing. And I promise you, I made this promise from the very beginning, and I've never wavered from it. Every single day I wake up and I go out here and I try to figure out what I can do today to overcome the system. I have consistently, for years, done nothing but focus on how do we fix this problem. I've served attorney generals, I've served Supreme Court justices, I've served senators, I've served cities, I've served counties. I will continue to do what I'm doing to bring attention to the issue. And this isn't a scam, right? This isn't for my own good. This isn't for my benefit. This is obviously for someone else's benefit. So, please get behind this. Please help me, help you, and let's get this done. All right? I'll review all of the comments, and I'll reply as I can. If you guys want reposting is one of the primary ways in which you can spread this information the quickest. Facebook, if you want to repost it, you come down and you click on the little arrow, it'll pop up with your repost. You can type something in there, don't type something, but that's going to get it down to your feed, and that'll move your information the quickest. Over here on TikTok, the easiest thing is you're going to come down to little 3 buttons. You'll tap on it. It'll pop up with a box here in the center. One of those options is a little circle. I think it's yellow with a circular arrow. It's repost. You just tap on it, and that's all you got to do. That puts it out into your queue. The more videos you repost, the quicker and more people that will view those. So we haven't had very good views on TikTok for a while here. I'm getting like 1,000 views on these videos that should be getting, I should be getting 500,000 views, but for some reason they're just not moving. So TikTok, please, if you can, get out there, share these videos, and get them out there onto your page and your queue. Please help us do that. YouTube, I don't remember how to do it there, but I'm sure you guys know. So, all right, that's it. I'm rambling on now. All right, guys, we are still accepting affidavits for both the indictment or the absence of the indictment by grand jury, as well as also the interference with the familial unit. I haven't decided, although I believe that it's going to be the familial unit affidavit, right? The interference with the familial unit. I believe I'm going to use that exact same affidavit for the probate court. I'm not certain on that yet because I'm just now kind of coming into how the guardianships and the probate court guardianships are going to be a part of this. But I'm staying with someone here. For some reason up here in the north, guardianships are just horrendous. The things that they do to mothers and fathers, stealing all their property and unaliving them is just terrible up here. So I know, and I've known for a long time that we were going to bring guardianships into this, probate guardianships, but I sat this morning talking with people about it, and so that's why I want to get out here on this live and explain once again the interaction between the absence of the indictment by grand jury, how that is a breakdown due process, and how that relates to the CPS, as well as also the elderly probate guardianships as well. Hopefully it was clear to you guys, but if you guys want to provide an affidavit, we are still accepting them. You can download the affidavits, either one of them, from justicewithoutlimits.org. That's justicewithoutlimits.org. You download them along with the instructions. We will still accept them, and you will send them to the North Carolina Post Office box. It's the only box that's available. It's within the instructions. All right, so North Carolina Post Office box, the only one that's still receiving them. For TikTok, one of my pinned videos has that address. It's also in the instructions. For Facebook, I think you're going to have to go out to the instructions, justicewithoutlimits.org, download it from there, and then send it into to that consolidation point there in North Carolina to Justin Carey. But we are continuing to accept them, and we will continue to accept affidavits until the court agrees to hear this case. All right, so keep them coming, keep sending them in. Please follow all the instructions, such as write legal mail on it, on the back, sign once you seal the envelope, sign across the upper, across above and below the lip. Once you seal it, that provides a tamper evidence seal, so we know if they get open somewhere along the way. So please continue to send those affidavits in. We will continue to accept them. And if you guys know anybody, please get out there and share. And then last but not least, we do only accept donations, right? You guys are not donating for me to come to your city, to fight a battle for you, to go into a courtroom for you. You guys are donating to this tour, right? You guys are believing in an outcome that we're going to reach this ending that I've envisioned and that I've described to you guys today. You guys believe that we're going to reach that ending, but the means in which we use to get there is up to me, all right? You are not donating to one of these scammers that's saying that we're going to come out to your city or whatever. We're going to fight. That's not coming from me, right? That's coming from Pure Cure and these other douchebags that are stealing from you, right? If you want to donate to the TER, what you're doing is you're donating because you believe that we're going to reach this ending that I'm describing here. That I'm going to be successful in being able to show that the states have a constitutional obligation written and codified, and that they've abridged those, and you believe that we're going to be able to reach that point, right? You believe that what we're doing is going to make it there. So what you're doing is you are donating to make sure that we reach that ending, but the means in which we get there is up to me, right? I'm led by the Spirit. I will not be bound by anyone's limitations. I'm not going to be required to do anything, right? Because that would limit my ability to be able to follow the Spirit and do what it leads me to do in every single thing that I do every single day. So I will not take on a contract. I will not come to any particular location. If I show up there, that's a blessing. But every single day, the Spirit's going to lead me, and I will not be bound to any limitations from what Spirit wants me to do. All right, that's what the donations are for. I will not work for anyone. I will only fight for everyone. Okay, I will only fight for everyone, and we can win this fighting for everyone in the same procedural situation. You have all been denied the exact same right in the exact same way and the exact same behavior from the judiciary. And I'm moving forward to show that behavior is a breakdown due process that Blackstone wrote about, going all the way back to Magna Carta. And that's what we're doing. All right. So if you want to donate, you can donate to Cash App, Chime, Venmo, PayPal. They are all exact same. So we shall be free. It's WESHALLBEFREE. We've had an amazing week. We now have the resource we need to be able to get out there and drive a little bit differently. We're still praying for the RV. Please continue to pray for us. But we thank you, Dave, so much for offering a teardrop trailer so we have a place to stay in. That's amazing, incredible. We just need the money now to be able to get the parts to get the van up in the condition we need. Thank you guys so much. God bless. Have a great rest of your day here, okay? Thanks, guys. Thank you. Thank you. Thank you, YouTube. Appreciate it, guys. Thank you so much. Thank you.